Guarantee refers to a contract made by a guarantor to make payments on the debtor's behalf if the latter was unable to pay back the creditor. Thus, there are three parties involved in this contract inclusive of debtor, creditor, and guarantor. In this contract, the guarantor's duty is to pay back the loan when the borrower defaulted in payment. This means that the guarantor assumes a secondary liability. In contrast, indemnity refers to an agreement made by a guarantor to make payments without conditions on behalf of the debtor. Thus, there are only two parties involved in this contract including creditor and guarantor. This is whereby the guarantor assumes a primary liability to pay back the loan on the debtor's behalf. The guarantee contract is not a Uberimi Fide contract. Creditor or bank and debtor are not required under any legal duty to disclose fact to the prospective guarantor. The bank does not need to disclose information regarding the conduct of the borrower's account to the guarantor. Although guarantee is easy to be taken as security, its value depends totally on the financial standing of the guarantor. And, the guarantor may escape liability because of technical defect in the security. There are four situations in which guarantor may escape liability. The first situation is the mistake as the nature of document signed. As emphasized in the case of Carlyle and Cumberland Banking Company vs. Bragg, a guarantor need to sign the guarantee form in front of the bank's lawyer. If guarantor was asked to sign wrong guarantee form, he will not be liable for any default by borrower. If guarantor sign the guarantee form outside the premise of the bank, he may also not be liable for any default by borrower. The guarantor may also escape from liability due to an undue influence. This means that the guarantor is executing the guarantee not on his own free will. If a guarantor is able to show that he signed the guarantee contract due to an undue influence, or if the debtor forces the guarantor to sign without willingness, the guarantor may not be liable for any default by the borrower. Apart from that, as highlighted in the case Mackenzie vs. Royal Bank of Canada, if bank makes misleading statements, or fails to provide accurate answer to a guarantor's questions, at the time the guarantee is taken, it is considered as misrepresentation. Hence, the guarantor may not be liable for any default by borrower. For instance, if the bank quoted wrong lending rate or loan amount to guarantor. Finally, as emphasized in the case of Lloyds Banks vs. Bundy, bank has fiduciary duty to guarantor, who is also its customer. If bank fails to observe its fiduciary duty, hence fails to advise the guarantor, who is also its customer, the guarantor may not be liable for any default by debtor. For instance, if the bank give insufficient time to the guarantor before he signed the guarantee form in order to take guarantee or indemnity as security, the bank needs to follow 5 steps. First, bank needs to check guarantor's financial standing. Second, bank needs to accept only written guarantee. Third, bank needs to explain necessary terms and conditions to the guarantor. Fourth, bank must include express provision, if guarantee intended to extend to transactions already concluded. Finally, the execution must be attested, or witnessed by lawyer, and stamped within 1 month. Stock or share is a shareholder's interest in a firm, that is measured by a monetary amount, and is made up of a variety of contractually protected rights. Shares of publicly traded companies that are quoted on Bursa Malaysia will be accepted by the bank. Unquoted shares are unacceptable because it is difficult to determine their worth, there is no market for them, investors would not want to acquire them, and it is challenging to transfer them to another investor. Normally, bank will accept registered shares for long-term borrowing, and accept bearer securities for temporary overdraft. Shares are very easy to value, easy to sell, and easy to transfer title to other investor. However, the value of shares are highly volatile, and it may subject to a company's director's approval for any transfer of title. There are 5 procedures to follow when obtaining stocks or shares. First, the client will open a computerized depository system CDS account with the stock brokerage firm. Secondly, the bank will open nominees pledge securities account NPSA. Thirdly, the client transfers shares covered by CDS to NPSA. Next, the bank will assess the shares, and make the client an offer, in which the margin of finance is up to 80%. Finally, the customer signs the deposit memo and accepts the credit line. Debenture is a contract acknowledging the company's debt to the bank. In this case, the bank is the debenture holder. A debenture establishes a fixed charge or floating charge on the firm's assets. Fixed charge refers to a legal charge over certain property, such as land, a factory, and equipment. In contrast, a floating charge refers to a floating equitable charge that does not connect to any specific assets until it crystallizes and covers the assets of the changing corporation. Assets secured by fixed charges include those that the debtor does not generally sell in the normal course of business. Floating charge is applied to all assets or specific asset classes, and they will include both current and future firm assets. Fixed charge will prevent the debtor from selling the charged asset without the lender's permission, and oblige the debtor to keep the asset in good condition while it is still in their control. Under a floating charge, the client keeps control of the charged assets and is free to conduct normal commercial operations with them. The floating asset freezes and crystallizes into a fixed charge in the event of a default or borrower liquidation, making the lender a priority creditor. There are 5 limitations of a floating charge. It permits the company to sell any assets that are not covered by fixed assets. A charge made within 6 months of a company's dissolution might not be legal. It is possible that some of the company's assets are not its property. In the case of a winding up, some preferential creditors can get payment before the holder of a floating charge debenture. Because it is free to deal with the assets, the corporation may establish a fixed charge in favor of a third party over the same asset. There are 4 rights of a debenture holder with regard to a default payment by the debenture issuer. The right to sue the borrower for payment, bring a civil lawsuit. Assets charged under a fixed charge must be sold in order to seek for a foreclosure order. The debenture holder must first give the company notice of the charge under floating charge. Next, right to make a petition or official request for the company's dissolution. Finally, the right to appoint a receiver whose primary responsibility is to realize or sell the company's assets, pay off the company's obligations, and carry on the business in order to restore the company's financial stability.